Got two questions. One's for David. So you said that you did work for APRA. So I just wanted to ask that you're the first person coming out of APRA who's not working there, has told us that it's not perfect. Nobody ever has pointed out the cracks in APRA. So do you guys have to sign any confidentiality forms once you've stopped working there, that you can't ever say anything about APRA?
So one of the issues that you get is there are a lot of workers who are unhappy with APRA, and they have various claims that they might allege, and typically they'll settle them with APRA. And almost always when you settle any sort of potential claim, part of that will be a non-disclosure agreement. So a lot of the disgruntled staff will have signed some sort of NDA that means they can't talk about it. I haven't done that, and so my real only obligations are, firstly, under the national law, you can't provide information that would identify a person in relation to anything that you learned at APRA, except to the extent that that's public. And that's why generally I won't refer to specific cases, because I can't. Other than that, there's a confidentiality provision to our contracts in relation to commercially sensitive information, but typically when I'm talking about dysfunction, that can't possibly be commercially sensitive because it's dysfunction. So one of the main reasons why you don't tend to see people speaking up is mostly because they're in a position where they can't. Either they have to sign an NDA or they want to go and get another government job. And I mean, by me speaking out, I've signed my death warrant in terms of working for the government again, which is fine. But most people who work in this industry don't have the ability that I had to go and practice. So that's why.
Thank you. And the second question is for anybody who can give me an answer for that. So the PSR, it's just like any, I guess, department, and when we go in a store, there are store people who have got targets to meet, like you have to sell 50 shirts in a month. Does PSR have any guidelines like that? You have to target 2 doctors a month or 50 doctors a month, because they are being paid. They have to justify their pay somehow. Is there any guidelines that anybody can?
I might answer that just to protect some of our speakers, because I'm not a lawyer. I've actually written that in an eloquent letter under the Freedom of Information Act. It's actually termed dividend incentivization, where certain people might actually get some certain bonuses if they actually find more doctors guilty. I'm yet to receive this, the Freedom of Information Act, which involves me getting access from the Treasury about what money has been paid to the director. I'm waiting.
What about your peers that's supposed to go and assess you and decide, okay, you haven't done your job, which nobody's ever seen, nobody hear about them. Do they get an incentive to, I mean, if they're going to say, this doctor is fine, he might lose his contract next time and he won't be able to be paid?
Again, wonderful question. My case is going to trial, hopefully, in September, and when we actually get closer to that point, we will be asking for what we call, I think, a potential discovery, which is a lot more powerful gun than Freedom of Information Act. So everything will basically come out at that point if there is anything to uncover, but that would be one of the things I'd be interested in.
If I can just add to that, as a vice president of the AMA, actually was responsible for the appointment of one of the directors of PSR. So although you go through that process and do the interview, you don't actually see the contract. That's very much a contract between the department, the PSR area, and probably the minister has to sign off on it. Generally, in those sorts of tribunals, and if you've ever had the dubious pleasure of sitting on anything like that, there's a very fixed fee and there's no real incentive of doing very much else. They don't really pay very much at all.
I have two questions. First of all, my first question is, with people who are actually members of the PSR, what standards or peer review process do they go through for, first of all, appointment, and then what training do they undergo to learning different policies and procedures, and then what review process by external auditors are there?
Do you have access to my email? Because that is exactly the terminology that was in my Freedom of Information Act. And the answer that I got, which has been admitted into as evidence in our trial, is that we do not have any policies or procedures. We do not have any training. We do not have any consistency, as a matter of fact.
No, it's just good governance point.
And can I add to that? The selection of panel members is apparently the function of the director, and the director is the person whose decision to refer a matter seems to be the death warrant. And in my opinion, I think I might have said this before, but in my opinion, the role of the director is undoubtedly covered by an obligation to afford natural justice, and plainly that was not allowed in Anchita's case, and with your support, she'll be able to knock over that bully once and for all.
Yeah, agreed. My second question is actually more of a personal question. What would it take to get onto the board of APRA? Because, I'm very interested in governance issues, and this point I just made, which was that Anchita just brought to everyone's attention about the poor governance process that's currently going on. I was just wondering, what must you do to get onto the board of APRA?
Can I just answer that from a broader perspective? The problem in Australia is we have a matocracy instead of a meritocracy. So you don't actually have to have any described skills to be able to get to that position. You have to get yourself in a position where I think the minister has to appoint you. And that is the matocracy that is at the core of part of the problem, because it's not on merit of the ability to participate in the pursuits of the Board of APRA.
If you go onto the APRA website, there's one of the drop-down menus has something about statutory appointments or becoming a board member, and all the information's there. It's a pretty long process. But as Paddy says, it's not merit-based, and board members come up for renewal every few years, and you would often see some of the best board members be shuffled off and the worst ones remain. So it's baffling.
Just two brief...
Except in Queensland, where the minister sacked more once, didn't he?
Just two brief questions and a statement. If it's the director that we have to really corner and challenge, and since almost 85% of doctors seem to fold at the director interview, then should we be bringing up evidence that we have got in emails from the health department where decisions that she has made and prosecuted doctors on her clinical opinion, which has then been proven to be faulty by both emails from the health department who will not corroborate her opinion, and letters that I've seen sent to me and to her from the Royal College of Pathologists of Australia refuting what she has indicted doctors from the uses of item numbers and pathology. So the quick example is, without rambling, is a Gold Coast doctor was told to pay back all treatments for Bowen's disease by using item 30196 because this obstetrician gynecologist director, in her opinion, said this is not a malignancy. After 21 business days, the health department wrote to me and said, we refute that and the item number can be used for that condition. We then got a statement from the Royal Australian College of Pathologists, who then sent a copy of the letter both to me and a letter that they sent to her was copied to me, saying, would you please desist in prosecuting doctors for the usage of this Medicare item number for a malignancy that you seem to be the only person who holds the view that it isn't. Now, obviously, the director is not going to respond to me or the health department saying, I've been sent this letter, I've been caught out, oh dear, the doctor of the Gold Coast better get his money back. Obviously, nothing will come of that because he's signed the Section 82 agreement and he's paying the money back because he's had the letter from the deeming authority. So my point is, I have several examples where what she has said to and prosecuted GPs for has been refuted by the health department in writing, which means she must be making decisions on her own with no medical or scientific background, threatening the doctor that what she says goes, and if you don't do what I say, I will then put you through a committee who will do what I tell them to do. So that's where we've got to attack it. The last very brief thing is, could you just, before we finish, tell us what the judge said in his May ruling that allowed you to defer it till September, because my academic reading of his summation printed on the PSR website, which they obviously printed to show that they may actually be winning the case, seemed to suggest that we really did not have much of a legal standing in challenging a peer-reviewed, open, transparent, non-closed system.
Can I ask the question of, is the director a medical practitioner?
Yeah, she's an obstetrician gynaecologist, yeah.
Can I suggest that you report her to APRA? I am
Very good idea, yeah.
I am serious about that. Put the Jekylls against one another, because that, if she has made that decision that has caused potentially clinical harm, then that is a matter that is reasonably referred to the national regulator, and then let's help them do their job better by a lot of input into how that might be, how that might transpire.
The problem, Paddy, is that, and this is where it just stems back to, and I'll answer the second question. I might get Douglas to answer that one, since he's a principal solicitor on the case as well. But first of all, the director can do that legally at the moment. That's the point of this entire day. The legislation allows and empowers the director to do that. And that's why the differentiation of argument is that we're saying the power that's enabling this to happen is wrong, not the merits of the individual case. And in regards to that, you know, I got a call at middle of the night, actually, in May, when that actually came out in May, in the annual report, and it was a two-piece of little thing that came out, and then subsequently I published the entire 8-page document of the summary judgment. In fact, there's a quite handful of people that have actually attended the hearing in May, who basically can attest to the fact that that was just one-liner. But I might just get Doug and potentially Julian to maybe talk about the judgment that happened in May and what we are trying to achieve in September.
Yep. Back on that point, the director has the power. She has all the protections of a High Court judge, and so does the committee, so she can do what she likes. Secondly, when she makes a determination, when she makes a decision, that decision then goes and gets ratified by the determining authority, which she also appoints and controls as well. And then it comes back to her, and then once the determining authority ratifies her decision for the doctor that you're talking about, that's pretty sudden death. So
I might actually, just so that there's no question of prejudice or bias or business interests or whatever, I might actually ask David Dunn, a complete external person who actually attended the hearing in May, to comment on because David, you've read the entire report and then you've also read the two-liner that was in there, and can you just answer his question if you don't mind? I think you would do the best job at this one.
I need to be careful too.
Yes.
I am in your matter being referred to. I guess, and trying to keep this very lay, in lay terms, the way I read it, that there is actually a substantive case that can be argued, and there were some procedural matters that needed to get attended to, more administrative, and that the judges was really just trying to say, listen, look, we need to hear this. It's been represented by counsel, and preeminent counsel, the QC for the Bundaberg trial was quite preeminent in this particular area, that there was a strong case to be heard, but they had to really just fix up some administrative matters they had at the time. That's what wasn't really printed out, and therefore it made it look like, they only gave pretty much half the story. One quick point I want to make is that I actually rang up the media back in 2011, and it still stands to this day. I asked who is responsible for interpreting the Medicare, the MBS item numbers for doctors. So when you ring up, if you're a practice manager or a nurse or you're a doctor, and the RSCGP said it wasn't them. The AMA said it wasn't them. This is printed, and I've got the article here. Went into the national papers. The Medicare said it wasn't them. The PHN said it wasn't them. Nobody in this country takes responsibility for interpreting the MBS. So there is no actual way of actually getting what is called Medicare audit-proof information, so you know whether
Ask MBS is included in that list. It is not an authority. If you have a bunch of letters from Ask MBS that says you should bill this way, that's not going to stand. That won't immunise you against a PSR audit.
Just a couple of comments about the case itself. one thing that I think was in the subtext of what the judge was saying was that because of the principles, the Bolam principle, which are often cited in medical legal cases, that there might be some difficulty. But in reality, we're not talking about the Bolam principle at all, because as David said, there is no standard that we're talking about. There is no standard to match it against. Today, the health department is the arbiter. It has to be the Department of Health, which is actually a good thing because at least there's someone to take responsibility. And I think that we have to charge our professional bodies, societies and associations and colleges to make that a clinical decision. And the reason is there is a directive currently circulated to PSR members from the director and the director's lawyer who are making case law against which to charge people. And then they're saying things like, you should not do a PSR test on people because there's no evidence for it. It's no use, despite the fact the Urology Society says you should do it, Paddy, and because the RSCGP says you should do it. And by the way, NHMRC says this is the latest guidelines that were printed early this year. And yet this body is starting to make case law against which to try people, which is fictitious.
I spoke to Bruce Topperveen, who's the General Counsel for the PSR, which was a very difficult 15, 20-minute conversation if you've ever spoken to that person. But he then wrote to me and said, because I'd written to the Health Minister where the government was in caretaker mode, and just the very brief line was, the director of the PSR does not determine inappropriate practice, commas, that can only be decided by a committee of the practitioner's peers. The director does not prosecute practitioners or force repayments, and neither the PSR nor the director have determined that any item is not worth funding, because I had accused the PSR of using this whole 30196 thing. And so, obviously I don't have it in writing exactly what he said in the 20 minutes that we spoke, but he was very emphatic that the PSR and his department, or him being the general counsel for the PSR and the director, do not, under any circumstances, interpret the Medicare rulings and make any decisions about whether it's appropriate. Well, obviously they do. So we have to sort of challenge the essence that they say that in writing that they are not the gatekeepers. And I've spoken to the health department, they say, we're two different departments, we make the rules, we'll interpret it for you. Well, the PSR has said, yes, it's the health department, we do not, under any circumstances, do any MBS interpretation. Well, that's obviously a flagrant lie, because they do.
Absolutely. The arrangements that are made before it goes to a committee is determined by the director herself, in this case, and the practitioner under review, under guidance of Bruce. So, absolutely, you're right. And unfortunately, as we've heard, they're completely protected by the legislation.
And it's the legislation that's the problem. Yeah.
And it is worth noting that in 1980, the Royal Australian College of General Practice took the Commonwealth to court, and on this particular issue, can the Commonwealth interfere in the doctor-patient relationship? And what they actually, and there was a High Court judge who made actually a comment in regards to that matter, and he actually said that the Commonwealth could not interfere in the doctor-patient relationship in relation to a private medical practice. Private medical practice. When you bulk bill, you change the entire relationship between the patient and the provider. You basically just told the Commonwealth, you've signed off and said, listen, I'm not going to bill any more the patient. I'm happy to take all payment. It basically gets assigned effectively when you sign that form, and what you're actually saying is, I'm happy to work for free gratuitously, and if the Commonwealth pays me, so be it. So that's what's happened here, and that's why as soon as you bulk bill, you waive a lot of your typical rights, and it's just something you should probably look at, saying that maybe, stop bulk billing, charge $1, whatever it is, take legal advice, and I'm sure there's more preeminently qualified people here who can comment on that, but you have changed your legal relationship by signing that form.
I'm not going to give legal advice. It's too dangerous. But first, I would say that although the statute doesn't provide it, the director is in substance making the decisions. And what General Counsel said is simply wrong. As a practical matter, what she decides seems to dictate the outcome, and it has immediate consequences for the doctor involved, and that is why, in my view, the decisions of the director attract the obligation of affording natural justice. It's for that reason that I'm not sure that I agree with the view that the legislation is the problem. I reckon with a good red hot go, this case that Anchita has could actually blow a hole in the way the PSR operates, and let's hope it does.
Thank you.
I just want to thank you really for opening all these Pandora boxes. It's really something that it's like a lace I can see going across the disciplines of health and mental health. I'm doctor in clinical psychology, and I do work with a lot of clients. So I used to work in Canberra for some time, and I was a discipline principal there, was hitting the wall with the public system, and very interesting ambiguity that was really, from my belief, bringing harm to clients. Then I left to private practice. Well, in 2016, I will just give you a very brief summary of what's happening. We are expected to know all the policy legislation, little letters and underlying letters. And of course we don't, because nobody ever taught us, nobody ever gave us, and we don't even know the language. You know, it's a legal language, sometimes depends how the policy is written, it's sometimes so ambiguous. Therefore, there is a professional Medicare helpline, which we call. So if we call professional Medicare helpline and they clarify for us how we should proceed, let's say with billing proceedings or anything, and we do as we are advised, then Medicare comes back and say, oops, you were given wrong advice. And now you have to pay back, or you have to do this, and you're guilty of not doing anything maliciously, but it's wrong administrative procedure. The problem with this, the amounts are huge, and administrative procedure is apparently not covered by indemnity insurance.
Well, it is.
If you're given advice by
Yes.
them that such and such is allowable and later disallowed, sue them or counterclaim on their application for you to recover the money,
Well,
counterclaim for the same amount, saying it was their negligence that caused you to bill it.
well, I need you on board then for that as far as individual case.
Yes.
But the thing is, I even have a name, and they even said, oh yeah, you were given wrong advice, but that's different department.
You're not in isolation, can I say?
I know.
And let's keep in
I think
touch, shall we say? Any other questions, Dom?
First of all, Anchita, thank you very much for today. It's been greatly appreciated. My name's Dominic Greco. I'm from My APRA, and I'm an organisation which represents health practitioners Australia-wide who have been affected by the bullying by APRA, and a lot of people who registered with our organisation have had their practicing licence suspended for really generally vexatious allegations on the majority of cases, and they've also had no natural justice. I just want to acknowledge David first, David Gardner, who's actually brought some life back into our organisation, who's actually been very brave and to come forward, put his career on the line to some degree, because anyone who challenges the government, as I did when I lost my career, they will come back at you. So I hope you make it successful private practice. On that, the actual question is for Julian Burns, if I may. Thank you for being here. It's a great privilege to have you here. Now, David's given us, now I'm representing several hundred individuals in my organisation, and David has provided us a direction to do something practical, I believe, which is the constitutional challenge under Section 75. It's going to cost some money. I suppose I'm asking Julian, do you think there's another way that we can also make APRA and the boards accountable for their abuse and their lack of natural justice towards health practitioners over the last 10 years?
I think the only honest answer is I don't know enough about it. 75(4) of the Constitution gives the High Court jurisdiction to hear cases between several states or between members of different states. That by itself just means the court has jurisdiction. It doesn't give you a cause of action. I don't know what the cause of action is, and I think at the risk of sounding like a lawyer, I'd need to know a lot more.
Absolutely, I totally agree, but thank you for that response.
Can I just say, Dom, that after hijacking Julian from the airport yesterday and subtly mentioned the issues and trying to talk about it, David and I are hoping that we will fundraise, because it will, it requires money to get a proper, whether it's Julian, whether it's a couple of other constitutional barristers, and then once that funding is in place, which I'm hoping, will happen soon, we will get a proper opinion. Once we get the opinion, we'll basically, shoot out a proper position statement, encouraging people, because there's two parts to it. We need to find a standing, we need to find a person we need to find another me, basically, in the APRA field. It could again be me, because I've been through APRA too. Fine, might as well. But it would be nice to have more people so we can sort of share the risk a bit, because I don't really have much to sort of, I'm a cockroach, there's not much the government will grab if I actually lose. So it would be nice to have a bit more assets in the back, I guess. But that's where we're at since this morning, isn't it, David, I think? Yeah. We've got about 5-10 minutes. So.
Anchita, if I could just make a point. One of the collectives that we haven't talked about very much at this meeting is the patients.
Yes.
And what I'm hearing and what I've felt and what I've learned over the years, that there's a lot of lack of accountability for people like the director of the PSR. There's a lot of lack of accountability of the CEO of the national regulator. The fact that the chair of APRA is actually the head of a law firm that is representing the College of Surgeons. They're the sort of problems that we can see and tease out, that as a collective we can kind of drive forward the need for that accountability. But one of the things that's also a problem is the accountability of healthcare professionals in the care of patients. So I see a lot of patients coming to me for a second opinion where the problem is the individuals that they might be seeing in the emergency department aren't really learning the lessons from the errors that have occurred, and they're not getting the accountability for those errors as they occur. So I think we can drive forward an expectation of accountability of those who are judging us if we seek and promote accountability for ourselves in the eyes of the patients, and therefore we recruit them to want the regulator to be better, because we're actually, as a collective, making sure that they're being looked after, so that we have a real rising up of the populace to get the legislative change that might be part of the solution.
Nick?
Thank you. I'd like to thank you all for being here today and helping us and giving us more confidence. The whole system is so slow. Should we be going to the media? People I've been looking for have aged with me. They're in their 80s and their 90s. I was doing home visits. The Medicare guidelines do not state anywhere that you have to justify a home visit. It says it nowhere. And unless I'm pretty good at English, it was my best subject in HSC. But they crucified me on that.
Thank you, Nick. Thank you.
I just spoke to the media just last week, and it was very interesting. They were completely disinterested in your views. They were extremely interested, and this is where we need to help the media, in real-life patient stories that are truly horrific, and I'm sure you all can think of one right now. Like the case studies I put up there, one of those is speaking to the media. This is the 7:30 report. Current. If you have patients right now whom you can reach out to who have had adverse outcomes to your issues, let me know, please, or let Anchita to let me know, because they are hunting as of now.
Thank you for that final point. As a matter of fact, literally I'm getting text messages from them saying, Anchita, can you just provide the public health interest side of things? And Joyce and I have provided about, I think, 3 or 4 patients, and I can't tell a patient to do so. I just let them know of the information, and they are contacting them directly.
Can I add one?
Yes, please. As a matter of fact, can you close the...
Can I just suggest this? If anyone tells any of you, if there's any public servant tells any of you, you face 12 months jail, 6 months jail, whatever, if you do X, ask them what section of what act provides that, and you will force them underground. If they are making threats like that, they are probably trying to hide themselves. I think it's great that Anchita has managed to bring all of you together in one place. It's really, really important to help her drive a hole through the bureaucrats who've treated her the way she's been treated and the way many of you have been treated. And if you want to do something about it, she's the guinea pig who's willing to get up there and get clobbered. So just support her.
Thank you very much, everybody, and thank you to all of you speakers, because this is your personal time, and I can't thank you enough. Those of you who are...